Okay, council, sorry about the late start here. We've been having some technical difficulties. Can you guys tell, are you guys hearing any kind of echo as I'm talking here?
It's not too bad.
I don't have any echo on my end.
Okay, good. We've been having some problems with that, so we just had to shut everything down and restart. And so anyway, that's the reason for the delay, but I'm ready to go on the record now. This is Dan Woods versus Dennis Dobson, case number 2013517. If I could just have both counsel put your appearances on.
Afternoon, Your Honor. For the record, Attorney Kyle Ream for the plaintiff.
Lance Zorhoff for the defendants.
Okay, great. Thank you. So we're on the record today for purposes of a status conference. I think the last time we talked, it's been a couple months. Mr. Ream, can you just kind of give me an update on where things are at and what you'd like to see for scheduling going forward?
I'll give you the update. I wish I had some better news, Judge. We had a facilitation set with Charlie Philippak, who's O'Neill, Wallace, and Doyle and Saginaw. And Lance's client was sick or in the hospital and it had to be adjourned. So the first available date that Mr. Philippak had was October 11th at 9:30. So our facilitation is set for October 11th at 9:30. And that's currently where we're at. We're waiting to facilitate the case. It's no fault of mine. It's no fault of Lance's. His client was sick and I don't remember what it was. Maybe Lance can tell you, but he went to the hospital or he had heart problems, something like that.
Yeah, it was.
Okay.
It was something unavoidable. He had some teeth that were impacted that he had to be hospitalized for and had to have it removed. That's as much as I know, but I know he couldn't do it. And so unfortunately we had to reschedule it with Charles. I would have loved to have had it by now and gone through the facilitation process, but it just did not work out. And this mediator is busy. That's the issue that we're having.
Okay. So I guess at this point, what I would suggest is for the court to simply set this for another status conference in November, following the mediation. Obviously, if you guys are able to settle it at mediation, just notify the court and we can take that date down. But otherwise, that'll give us an opportunity to figure out where to go next. Either of you have any objection to that?
No, Judge.
No.
Okay. All right. Anything else that either of you wanted to address while we're on the record today?
No, thank you.
Not for me either.
Okay. Sounds good. Thanks for your patience and you're both free to disconnect at this time.
Thank you, Judge.
Thank
Bye,
you.
Lance.
Bye.
Definitely sounds a lot better.
Good.
Like their voices are
Yeah.
better.
Yeah, because they were in and out.
Okay, counsel, we're on the record now in Dalton versus Dalton. This is case number 2414396. We had some technical difficulties here in the courtroom with Zoom today, so I apologize for the delay. That's why we're starting late. But if I could have both counsel put your appearances on the record, please.
Good afternoon, Your Honor. Elena Lentz for the plaintiff, Kelly Dalton, who is appearing with me today via Zoom.
Good afternoon, Your Honor. Brianne Neros on behalf of the defendant, David Dalton, who is with me.
Okay, so I do have a copy of a proposed judgment and a mediation report from June indicating that the parties have settled. On behalf of plaintiff, Ms. Lentz, did you want to move forward today with taking proofs?
Correct, Your Honor.
Okay, and Ms. Neros, are you on board with that?
I am, yes.
Okay, so I'm going to have both Mr. and Ms. Dalton, if you both could raise your right hands, please. Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
I do.
Thank you. You can lower your hands. And Ms. Lentz, if you wanted to proceed with proofs from your client.
Thank you, Your Honor. Kelly, can you please state your full name for the record?
Kelly Marie Dalton.
And did you file a complaint for divorce on February 14th, 2024?
I did.
At the time that you filed the complaint for divorce, had you been a resident of the state of Michigan for 180 days?
Yes.
And at the time you filed the complaint for divorce, had you been a resident of Kalkaska County for 10 days?
Yes.
Were the allegations contained in the complaint for divorce true at the time you filed?
Yes.
And are those allegations still true today?
Yes.
Has there been a breakdown to the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood they can be repaired?
Yes.
And Kelly, I apologize for the intrusion, but are you currently pregnant?
No.
And do you and the defendant share any minor children currently?
No.
Did you and the defendant, or Kelly, I'm sorry, did you read the judgment of divorce before you signed this?
Yes.
And does that judgment of divorce incorporate the agreement that you and the defendant reached at mediation?
Correct.
Do you understand and agree that in terms of spousal support, you are to receive a lump sum payment of $17,500, and that's from the defendant. After that $17,500 is received by you, spousal support is forever barred, which means you cannot return to this court at a later date and time and request additional support. Do you understand that?
I do.
And you agree to that?
Yes.
Kelly, do you believe the terms contained in the consent judgment of divorce are fair and equitable?
I do.
And do you understand that if the court approves the judgment of divorce today, you're waiving your right to a trial? At trial, you could have done better, you could have done worse, or you could have done about the same as this document.
I do.
Almost done. Kelly, are you requesting that your name be restored, that being Jimenez, Jimenz?
Easy. Yes.
Easy,
Correct.
excuse me,
Yes.
Jimenez.
Correct.
And are you doing that for any like ill or fraudulent purpose?
No.
Kelly, are you satisfied by the efforts of your attorney?
Yes.
Thank you. I have no further questions, Your Honor.
Thank you. Ms. Neros, did you have any questions for Ms. Dalton?
Not of Ms. Dalton, no.
Okay, and did you want to take any testimony from your client?
Just a few questions, if I may.
Okay, proceed whenever you're ready.
Thank you. Mr. Dalton, can you please state your full name for the record?
David Bruce Dalton.
And you heard the testimony of the plaintiff, Ms. Kelly Marie Dalton, now Kelly Marie Jimenez.
Yes,
And you generally agree with what she's testified to today?
yes,
And you also have had a chance to review this consent judgment of divorce and adhered your signature to the last page electronically, but you recall having signed that?
yes,
And you believe that the terms of this judgment to be in accordance with the June 18th mediation agreement?
yes,
And you also understand that you had a right to a trial in this case where the judge could have ruled more favorably, less favorably, or about the same as the ultimate settlement reached in this agreement?
yes,
And you also are asking that this court sign this consent judgment and grant you a divorce.
yes,
And you understand that the terms of this judgment are final and cannot be undone absent some exigent circumstance such as fraud or duress.
yes.
I have nothing further. Thank you, Your Honor.
Ms. Lentz, did you have any questions for Mr. Dalton?
No, Your Honor. Thank you.
Okay, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of both parties. I reviewed the judgment. It does contain all the provisions required by statute and is generally equitable. The court will grant the divorce, and I'm signing it with today's date. Ms. Lentz, on behalf of plaintiff, anything else that we need to address today?
No, Your Honor.
Ms. Neros?
Nothing for me.
Okay, thank you. That's all for today. Both sides are free to disconnect on this file.
Thank you.
Okay, if I could have you both unmute, please. And ma'am, are you Christina Ormsby?
Yes, I am.
Thank you. And sir, you're Silas Ormsby, is that correct?
Yes, I am. That's correct. Thank you.
Okay, and this is case number 2414428. The record should reflect both parties are connected by Zoom video. The last time we met was back in June. The court referred this to community mediation. And Ms. Ormsby, as a plaintiff, I see that we did refer it out. Were you ever contacted by community mediation, or were you able to participate in that?
Yeah, we both participated.
Okay, were you able to reach an agreement?
We have.
Okay, Mr. Ormsby, do you agree with that?
Yes.
Okay. So what we can do today, so that you wouldn't have to have any more court appearances, I can take the testimony that I need to take from each of you to establish the grounds for divorce. But there's a final document that would need to be filed to close the case and finalize the divorce, and that document's called the judgment of divorce. And Ms. Ormsby, when you filed for divorce in this case, did you get your forms off of an online website, or how did you get your forms?
I came into the clerk's office. Or wait, I'm sorry.
Okay, Mr. Ormsby, you got the forms from the clerk's office?
Yes.
Okay. I'm sorry, you were the plaintiff in this case. I had it backwards. So Mr. Ormsby, there should be a form. Again, it's called the judgment of divorce. So I would need you to fill that out and include the agreements that you made through mediation in that, and then get that to the clerk's office here in Kalkaska. And that's a very important step, because your divorce won't be final until you submit that judgment of divorce and I sign it. That's what ends the case. So it's really important that you follow through with that step after today, because even though you won't have any more court appearances and I'm taking the testimony I need, the divorce won't be final again until I sign that. All right.
Okay.
Do you have any questions about that part of it?
Just my life has kind of been an upheaval, so paperwork has been difficult to keep track of. Can I pick up another form of that, a judgment of divorce from the clerk? And I can fill it out there.
Yes, you can.
Okay.
Okay. So if I could have both of you raise your right hands, please. Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Do.
I do.
Thank you. You can lower your hand. Mr. Ormsby, you're the one that filed the complaint for divorce in this case, and did you sign that complaint before you filed it?
Yes.
At the time that you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Kalkaska County for at least 10 days?
Yes.
In that complaint, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony had been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you signed that complaint?
Yes.
Does that remain true today?
Yes.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
And you participated in the mediation process with Ms. Ormsby, is that correct?
I did. Yes.
And through that process, you reached agreements with her in terms of dividing up any property or assets or debts of the marriage?
We did. Yes.
And do you agree to abide by that agreement that you made?
I do. Yes.
Does that agreement provide that you are going to receive any spousal support or alimony?
No.
Okay, you understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that?
I understand that.
Okay, thank you. Ms. Ormsby, have you heard all the questions that I asked Mr. Ormsby?
I have.
Did you hear all of his answers?
I have.
Do you have any reason to believe that any of the answers that he gave were untrue?
I do not.
Are you currently pregnant?
No, I'm not.
And you reached an agreement with Mr. Ormsby regarding the division of any property and assets and debts of the marriage, is that correct?
Yes,
And do you agree to abide by that mediation agreement?
yes,
And as part of that agreement, are you going to be receiving any alimony or spousal support?
no,
And as with Mr. Ormsby, you understand that you would be waiving that forever and you would not be able to come back later and ask the court for that.
I understand.
Okay, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of both parties. The court will grant the divorce. Again, it won't be final until that judgment of divorce is filed. So Mr. Ormsby, again, just please make sure that you follow through with that step. Do either of you have any questions at all?
The
No,
only question, oh, sorry, go ahead, Silas.
I just answered his questions. Go ahead.
Oh, my only question is the matter of changing my last name. I requested a different last name change.
Okay, what are you asking your last name to be changed to?
Alexander?
Alexander, okay. Common spelling for that?
Yes,
Okay. So Mr. Ormsby, when you fill out that judgment of divorce, there's a line for you to indicate that. You'll just need to fill that in on that judgment as well.
Okay.
And then, Ms. Ormsby, once that judgment is signed by the court, then your name will legally be changed. So you're going to want to get a copy of that once it's signed for your records, because when you change your identification and other documents, they're going to want to see that judgment of divorce that changes your name, okay?
okay,
Christina, I can bring you a copy of that.
okay.
Okay, thank you. That's all I have for today, and you're both free to disconnect at this time.
Thank you.
Could be better.
Okay. Well, that's,
Can it always?
yeah.
Play, so. Okay, let's go on the record in Nellis versus Kalkaska Memorial and Munson, case number 21-13787. And if I could have both counsel please put your appearances on the record.
Yes, good afternoon, Your Honor. John Elliott on behalf of the plaintiffs.
Good afternoon, Your Honor. Kevin Lesperance on behalf of the Kalkaska defendants.
Okay, this is set for a hearing today on the Kalkaska defendant's motion for entry of a qualified protective order. Munson joined also in that request. I did have a chance to review the briefs from all sides here, as well as the attachments. So I'm familiar with all the factual allegations that both sides are making with regard to what has or hasn't gone on during this process. I also had a chance to review the law cited by both parties regarding qualified protective orders. So Mr. Lesperance, in support of your motion, any oral argument here today?
Yes, Your Honor. Very briefly, I know Your Honor is very familiar with these issues. They have come up in other cases that we've had, although recently most of those cases have resulted in stipulations to a qualified protective order. We believe that we are entitled to that under the Holman, Michigan Supreme Court decision that we cited. In most of these cases, the issue comes down to whether or not additional provisions are appropriate or not. And so we cited the court to the, I know I won't end up saying it correctly, but the Court of Appeals decision in the SPAC case, SZPAK, and that case basically held that adding additional provisions to the order without justification was an abuse of discretion. And that's our standard brief when these issues come up. In this case, we tried to get a stipulation from the other side. They failed to respond, so we filed our normal motion, and now we have their response. And in essence, as I understand their response, what they're asking the court for is to reject entry of a qualified protective order completely. And as justification, they make two allegations, the second one of which resulted in co-defendants counsel filing a reply brief to address, and I think they addressed it very appropriately, the accusations that were made against co-counsel for the defense, Miss Gretchen Olson, who unfortunately is not able to be here today. So I'll let her office and her brief speak for itself. As to me and my clients, there's an allegation on page 3 of their brief that essentially we put affidavits into the record for the, quote, sole basis of attempting to cause this honorable court to be misled. I believe that is factually inaccurate. I don't believe that that has ever been the finding of Your Honor. I don't believe that that is true. I find that personally offensive, that they would allege that we have attempted to mislead the court. We can have a side trial on that issue, and I know that reply briefs are generally not permitted, so we did not file one, but that is absolutely false, that accusation. I take offense to it. I don't believe that it is a basis for denying us our right to a qualified protective order. They haven't really sought any additional conditions, and I would ask that Your Honor deny the motion and admonish counsel from making similar remarks in the future because it's unbecoming to the court. Thank you.
All right, thank you. Mr. Elliott?
Thank you. Your Honor, I agree with Mr. Lusbrance that you should deny his motion, but I assume that's not what he meant when he asked you to deny it. Your Honor, I'm sorry that he takes offense to this, but I provided you the deposition testimony. His 3 clients, who are all parties and all witnesses, all testified to signing affidavits placed in front of them by their attorneys. They all testified to signing materially false affidavits and acknowledge that they were false. And if Your Honor recalls, this was all happening at a time when they were fighting to provide discovery and when they were arguing governmental immunity. They were trying to get our case dismissed and presented these affidavits, including changing what was allegedly happened. The 2 individuals who were there that dropped our client on the ground, they signed affidavits saying that they reviewed their video and based their affidavits upon that because they saw what they had done. Well, at their deposition, they admitted that was false. They had not reviewed their video. At the deposition, they claimed that they admitted that they had seen the divot in the ground before they dropped my client, yet in their affidavit.
Mr. Elliott,
Yes,
can I just stop you for 1 second? Because I read your brief, so I understand what you're saying. How does that relate to the qualified protective order?
Your Honor, it relates to qualified protective order because the whole purpose of that is to supposedly put us on somewhat equal footing. In fact, I just switched my page. According to Holman, the case that the defendants rely upon, the HIPAA does not require you to grant a motion for protective order and that you retain your discretion to issue it and to impose conditions. We're asking if you're going to issue it to impose conditions. The reason for that being that in this case, there is good cause for that. I read Ms. Olson's response. I know you read it as well. Unfortunately, to me, it looks like she's digging herself a deeper hole. She's saying that she never contacted this person. The person had reached out to her, yet our office was contacted because this individual said something during treatment to our client. That's how we found out she had contacted before we had ever even submitted a deposition notice to her. She didn't reach out and call. Her deposition that I sent to you, Your Honor, you read her deposition testimony. Ms. Olson called her, not her calling Ms. Olson, as Ms. Olson put in her reply brief that was filed. There has been communication here between the defense attorney and treaters before a qualified protection order was open. We have 3 medical providers who happen to be parties here who have admitted to signing false affidavits. That's why we're asking you to go by your original order, Your Honor, and that we conduct depositions. We're asking that we be present during these communications. We ask that all communications be conducted in depositions where the record cannot be misconstrued, where you don't have to worry about someone saying one thing happened that didn't happen and the witness is saying a completely different thing happened. We will have it on the record. These individuals do not have to talk to any of us. Not me, not Mr. Lusbrance, not Ms. Olson, not anybody. They can do it when subpoenaed at a deposition, and that's what I would ask. Your Honor, I just saw today a case in Lawyers Weekly where a case, summary disposition was granted due to fraud committed during litigation. We may be considering that in this case. I don't think Mr. Lusbrance should be taking offense at what's occurred. I'm offended that I have to go through and dig through multiple depositions to find out that people are submitting false affidavits to this court. And that is why I think we need these extra conditions if an order is going to be entered, Your Honor.
So, I understand your argument with regard to what you're alleging as to Ms. Olson, that she had some ex parte communications there prior to entry of the order. What I'm not seeing, and maybe you can help me, is the connection between the allegedly false affidavits of 3 individuals and the qualified protective order. Like, I mean, are you saying that because that if that is in fact the case, that's just evidence of more wrongdoing, and so the court should take that into account when looking at the qualified protective order?
No, I fully understand your question, Ariana. No, I read through these cases. I read many cases on this issue. They come down to, in many of the decisions, I think and I probably will speak it also, but the SBAC case, these come down to the arguments that in many cases, there could be, alleged pressures put on medical providers that, hey, this helps, if you testify against them, it hurts the whole profession, it brings the bar down. But they're saying we don't have, in the Spatz case, they did not have any specific instances relating to that case to believe that that was occurring. What I'm saying is that the three parties in this case who have submitted affidavits have acknowledged that they were signing affidavits given to them by defense counsel, and that they signed them, and that they were false, and that they were blanketly signing them. And then they were utilized by defense counsel to try to get our case dismissed. I'm not alleging that defense counsel knew they were false. They didn't know what would happen that day. But the affiants are pressured, maybe not intentionally, but in this case, for whatever reason, maybe it's because these are basically the only two games in town. And seemed even Miss Olson didn't know apparently who she represented. These individuals are pressured to sign things when presented by these attorneys. I'm not claiming that Mr. Lesperance is the one who falsified an affidavit. He doesn't know the facts. Someone from his office wrote down what they believed or hoped that these people would say, and these people did sign it. I think that shows that in this particular case, there is good cause. I think it goes towards it, in addition to the communication that happened between Ms. Olson and a third-party provider before there was any qualified protective order. I think that is a clear factual distinction from this case, from the Spatz case, where they did not have any of that evidence. Here we have it. It's not disputed. They have admitted their affidavit was false, and they said they signed it because it was presented by defense counsel. And I believe Mr. Aylesworth specifically said, I signed it carte blanche. That's why I think we need these protections in this case, Your Honor.
Okay. All right. Thank you for clarifying that. And Mr. Lesperance, since it is your motion, I will give you an opportunity to respond.
Thank you, Your Honor. I disconnect that you're mentioning, and by the way, I want the motion granted, not dismissed, just so that the record is clear, of course. The disconnect that you're mentioning is that my individual clients aren't going to go meet with the healthcare providers. I am, or people from my office. And I take my reputation very seriously. I've been vetted by two organizations, the American College of Trial Lawyers and ABOTA. And been accepted into both of them after extensive vetting. I take my personal reputation very seriously. There is no indication whatsoever that defense counsel is going to, or is capable of, or has done anything nefarious in this case. I think that plaintiff's counsel essentially acknowledged that when he just spoke, and that's the disconnect. I'm going to be the one doing the meetings, and there's just no reason for putting any additional conditions or denying the motion. Thank you.
All right. Okay. Thank you. Again, I did read through the briefs of the parties. I read through all of the exhibits that were attached to both sides' briefs in this case. I think number one, I think both parties accurately cited the law with regard to qualified protective orders. I think both sides, I think, generally agree on the standard that the court has to apply, and that the court does have discretion whether or not to grant a qualified protective order and whether or not to impose conditions on that order. And I think both sides acknowledge that in their brief as the legal standard. So, what it really comes down to here, and in my view, it's really about the access between attorneys and healthcare providers, and whether or not there's sufficient evidence of some kind of problem with that would require the court to put conditions on. And I haven't had very many contested motions on qualified protective orders. Most of the time parties are able to stipulate to those, to the extent that there are some kind of concerns, they're able to stipulate to conditions. Unfortunately, that obviously is not the case here. And generally the way that discovery's gone, I guess I'm not extremely surprised by that. I think the parties here have had a really difficult time working together to get discovery done and on really what should be pretty simple issues like entries of stipulated qualified protective orders. Be that as it may, I don't think there's enough evidence here of wrongdoing on the part of counsel. I think Ms. Olson's explanation for her contact is a reasonable explanation that doesn't involve wrongful conduct on her part. I'll also say that, you know, I've had both of these firms and these lawyers practicing in front of me for over 10 years and many cases in front of this court. I've never had a case where they've been accused by plaintiffs in cases with no less at stake than what's at stake in this case of some type of wrongdoing. And it doesn't make sense to me that in this one particular case, they're going to start doing that for some reason, where there haven't ever even been allegations of that in the many cases that I've had with them. And so I don't find that there's adequate showing here of some type of wrongdoing or potential for wrongdoing or potential for improper pressure to be brought to bear in this case. So for those reasons, the court finds that it would be appropriate to enter a qualified protective order. The court will grant Mr. Lesperance your motion. And I know that there was a proposed order submitted as Exhibit A. Is that the order that you're asking the court to enter?
Yes, Your Honor.
Okay, and I did review that order. It does provide for standard conditions. And so the court will sign that order. Mr. Lesperance, I'd also request that you submit an order under the 7-day rule, just for the reasons stated on the record.
Yes, Your Honor.
Showing that the court has granted your motion here today.
Yes, Your Honor. Thank you very much for your time today.
Okay, thank you. That's all for this hearing. All parties on this case are free to disconnect at this time.
Thank you, Your Honor.
Thank you, Your Honor.
All right, I have a Mr. Brandt connected. Mr. Brandt, can you unmute and tell me what case you're here for?
Okay. Good afternoon.
Hi.
Do you need the case number?
No, just who are I don't see your name on my docket, so I'm just wondering if it's a different case that you're calling in on, or?
No, it's a divorce case.
It's what?
Divorce case.
I'm sorry, you're breaking up a little bit. Can you say that again?
Divorce case.
Divorce case?
Yes.
Do you have a case number? Because I don't see yours on my docket.
Just a minute. Yeah, this happened last month also, and so went back to, they give us the rest of the papers and we submitted, and they said that was the only thing we had to have. And we called this morning and got the number to get it back on here. But the same thing happened last month.
It is on here for today, but it's on the document.
Okay. She's I guess we don't have the case right now.
Okay, Mr. Brand, I'm just gonna have you hold on for a minute. We're gonna grab your file and see if we can go forward with your case here today, okay?
Okay, thank you so much.
I'm just gonna put you on hold and I'll bring you back in once we have that.
Okay.
Can anybody hear us now?
All right, ma'am, you're signed in with a fire tablet. Can you tell me your name, please?
Jennifer Martindale.
Martindale, okay. And then I have somebody signed in on a Motorola device.
Yes.
Are you
Jacob
Mr.
Martindale.
Martindale?
Yes.
Okay. Terry, can you grab that Martindale? Terry, can you grab that Martindale? Okay, we're on the record in Martindale versus Martindale. This is case number 2414442. Both parties, thank you. Both parties are present by Zoom video. And okay, it looks like this is our first hearing before the court. So typically at this hearing, I try to determine whether or not you've been able to reach any agreements regarding dividing up the assets or debts of the marriage, or whether there are things that the court needs to decide, and whether or not there's a potential for mediation in this case to resolve any issues. So Ms. Martindale, you're the plaintiff here. Have you and Mr. Martindale been able to reach any agreements regarding how to divide things up?
Yes, sir.
Okay, are there any issues from your standpoint that remain for the court to decide?
Nope.
Okay, Mr. Martindale, would you agree with that?
Yeah, we've had pretty good discord and talk, and it's all been resolved.
Okay, so I can set this for a final hearing date. At that final hearing, I will take the testimony that I need to take from both of you to be able to grant the divorce. And prior to that point, Ms. Martindale, when you filed for divorce, did you get those forms from like an online website or somewhere?
Did.
Okay, so if you go to that same location, there's a final form. It's called a judgment of divorce. And that is the form that closes the case and finalizes the divorce. So I'll need you to print out that form, fill that out, and turn that into the clerk's office here in Kalkaska prior to that final hearing date. And the court, our office will send you notice of the date and time of that final hearing, just like we did for today.
Okay.
So once you get that final hearing date, you'll need to make sure that you submit that judgment form prior to that date, okay?
Okay.
And then again, at that date, I'll take the testimony that I need to take from both of you under Michigan law to establish the grounds for divorce, and I'll sign that judgment, and then the divorce will be final at that time. Ms. Martindale, do you have any questions at all?
I have requested to change my name back. Does that go get finalized during that final hearing?
You broke up a little bit there. You requested what?
My name to be changed back. Does that get gone through over the final hearing as well?
Yeah, so that judgment of divorce form will have a line on it for you to fill out that you want to have your name changed and what you want it changed to.
Okay, perfect. Thank you.
Okay, Mr. Martindale, did you have any questions?
No.
Okay, all right, so look for that date and time of that next hearing in the mail. And that's all for today. You're both free to disconnect. Thank you.
Thank you.
Okay, Mr. Brandt, I do have your file and we can go forward with finalizing your divorce here today if you'd like to do that.
I would, please.
Okay. So I do need to just note a couple things for the record before we get started. It does look like Ms. Brandt was notified or was properly served with the summons and complaint in this case. She did not file any kind of answer or contest the divorce. And she was provided notice of the date and time of today's hearing, as well as notice of the default. This was set for 2:45. Ms. Brandt has not appeared to contest the divorce. So Mr. Brandt, I'm going to place you under oath and I'm going to ask you a series of questions. The questions that I'm going to be asking you are those that I'm required to ask to establish the grounds for divorce under Michigan law, okay?
Okay.
So if you could raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand. Mr. Brandt, you filed a complaint for divorce in this case and you signed that complaint. Is that true?
Yes.
At the time you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
No.
Yes,
What?
you were a resident.
Oh, resident, you said. Okay, yeah. Resident, yes.
So whoever's with you there, ma'am, I'm sorry, I can't have you answering questions for Mr. Brandt. So you're not under
Okay.
oath and I have to take the test from him. So Mr. Brandt, I just need to make sure you answer all the questions. So I'm going to ask that question again. Had you been living in the state of Michigan for at least 180 days at the time that you filed for divorce?
Yes.
Had you been living in Kalkaska County for at least 10 days at that time?
Yes.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony had been destroyed and there remained no reasonable likelihood that your marriage could be preserved. Was that true when you signed that complaint?
Yes.
Does that remain true today?
It does.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
To your knowledge, is Ms. Brandt currently pregnant?
No.
Under the judgment of divorce in this case, you would not be receiving any alimony or spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes.
And have you and Ms. Brandt already divided up any assets or debts of the marriage?
Yes.
Do you own any real estate together?
No.
Okay, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of Mr. Brandt. The court will grant the divorce. I'm signing that judgment with today's date, Mr. Brandt. If you need a copy of this for your records, you can get that here at the clerk's office in Kalkaska. But as of today, your divorce is final. Do you have any questions for me?
I don't believe so, Your Honor.
Okay, thank you. That's all for today, and you're free to disconnect at this time. All right, Miss Lane, are you able to hear me okay?
Yes.
Okay, we'll go on the record in Lane versus Lane, case number 2414457. And the record should reflect that the plaintiff, Miss Lane, is present today by Zoom video. This hearing was set for 3:15. It's now 3:20. I don't see anyone else appearing on this file. And Miss Lane, I have this set today for entry of a judgment of divorce in your case. Is that how you wanted to proceed?
Yes.
Okay, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can lower your hand. Ms. Lane, I'm going to ask you some questions. The questions that I'm going to be asking you are the ones that I'm required to ask to establish the grounds for divorce under Michigan law, okay? So you filed a complaint for divorce in this case and you signed that complaint. Is that true?
Yes.
At the time you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Kalkaska County for at least 10 days?
Yes.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony had been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you filed the complaint?
Yes.
Does that remain true today?
Yes.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
Are you currently pregnant?
No.
As part of the divorce, you are not going to be receiving any alimony or spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes.
Do you own any real estate or real property with Mr. Lane?
No.
And have you and Mr. Lane already divided up all the assets and debts of the marriage?
Yes.
Okay. All right, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of the plaintiff. The court will grant the divorce. I've signed the judgment with today's date. Ms. Lane, so your divorce is final as of today. Also, you're asking to have your last name changed to Barber, is that correct?
Yes.
So from today forward, your name will be legally changed. So you may need to get a copy of this judgment from the clerk's office here in Kalkaska, because when you change your identification and other documents, they're going to want to see a copy of your judgment of divorce, changing your name, okay?
Okay.
Do you have any questions at all?
I don't think so.
Okay, that's all for today's hearing, and you're free to disconnect at this time.
Thank you.
Thank you. All right, we also had scheduled at 3:15 Ecker versus Ecker. That is a divorce case. And that was set for 3:15. Notice was mailed out to both parties in June. Neither side has appeared. The court will set it for one more hearing. If neither party appears at that hearing, the court will dismiss the case. I did want to make a record also. We had a case set for 1:30 Graziano versus Two Spokes LLC. That is case number 2314241. No parties appeared on that file. It does appear from the file that the case was settled. The court will set it for one further status conference to check on the status of the closing documents in that case in 30 days. Okay, Mr. Jaskowski, are you able to hear me okay?
I can, Your Honor.
All right, we're on the record in Cold Springs Township versus DSV SPV 2 LLC, case number 24-14452. We have Mr. Jaskowski here on behalf of plaintiff Cold Springs Township. This is a motion here today for entry of a default judgment in this case. For the record, I did have a chance to review the file. It does appear that the defendant was properly served with the summons and complaint in this case. The defendant did not answer or otherwise defend as required under the court rules within the time provided. There was a default entered in June. So the court finds that from a procedural standpoint, it would be appropriate to proceed with the default judgment. I also note for the record that the defendant was provided with notice of the date and time of this hearing today, which was 3:30. It's now past that time, and no parties have appeared to defend this motion. Mr. Jaskowski, was there anything for the record that you wanted to state in support of your motion here today?
Your Honor, we would rely upon the written motion. There was a proposed default judgment submitted with the motion. We did not receive any type of response, either written or any type of phone contact from the defendant in this matter. Obviously, this is a blight matter that the township is concerned about and is just seeking to have the property cleaned up. And we would respectfully request entry of the default judgment that we attach to the motion. Thank you.
Okay, for the reasons I've stated here, I do find it would be appropriate to enter that judgment. The only thing I'm going to change, Mr. Jaskowski, the date on the face page is 8th of July, so I'm just going to change that to August 6th.
Thank you.
And then I've signed the default judgment. Is there anything else I can address for you on the record here today?
No, thank you, Your Honor.
Okay, thank you. You're free to disconnect.
Thank you much.
Okay, we'll go on the record. This is Jason Wright versus Aaron Weaver, case number 24-14403. Mr. Elhart, you're appearing on behalf of plaintiff Mr. Wright, is that correct?
That's correct, Your Honor.
Okay. And Mr. Weaver, you're the defendant?
Yes, Your Honor.
Okay, you're Aaron Weaver, is that correct?
Yes, I am.
Okay. So we're here for a hearing today on plaintiff's motion for entry of a default judgment in this case. Mr. Elhart, was there anything that you wanted to state for the record in support of your motion?
No, Your Honor, other than the balance due currently is $11,400, and we would ask for judgment on that amount.
Okay, I'm just looking, did you submit a proposed judgment with your motion?
I did not, Your Honor.
Okay. All right, Mr. Weaver, was there anything you wanted to say regarding this?
Yes, I would, I'd like to request for an adjournment. My business is an Ohio-based business. I'm a resident of Ohio. So my attorneys, advised me that they cannot, practice in the state of Michigan. I have reached out to an attorney in Michigan here. However, July 4th, I tore my Achilles tendon, had surgery July 11th, and I got this note on July 8th. So I've been down since then and have not been able to meet with any attorney. So I would just ask if maybe I could get like 21 days to seek legal advice from an attorney in the state of Michigan.
All right, Mr. Elhart.
Mr. Weaver's business runs in Kalkaska County, Your Honor. He contracted in Kalkaska County. I don't know where he's a resident or where he isn't a resident. Nevertheless, I think it's appropriate to proceed ahead at this time.
All right, you're not willing to stipulate to an adjournment?
I'm not, Your Honor.
All right, well, Mr. Weaver, this complaint was filed, let's see, in February. You were served with it in May, I believe, May 19th. So you've had several months to obtain counsel. Based on the file, there's no reason why the court should not enter judgment, default judgment. I would still encourage you to seek the advice of an attorney. There may be a way for you to, for your attorney to challenge that default judgment even at this stage. So I would encourage you to seek legal advice. But at this point, based on the status of the file, the court does not have a legal reason not to enter judgment as requested by Mr. Elhart. So
I'll provide a judgment, Your Honor. Thank you.
all right, and then Mr. Weaver, if your attorney, if you hire an attorney and that attorney is going to be representing you, I would encourage you to have that person get in touch with Mr. Elhart as well.
I will do, Your Honor.
Okay.
Thank you, Your Honor.
All right.
Have
Thank
a
you. That's
safe
all
day.
for today's hearing, and all parties are free to disconnect at this time. This also concludes the court's afternoon